All right. Good afternoon. Thank you everyone for joining us for this afternoon's convening. My name is Anna Young. I'm the presiding juvenile judge up in Yavapai County. I'm the chair of Committee on Juvenile Court. And so I am co-facilitating this convening together with Judge Goss and Judge Starring from the Court of Appeal. Just a couple of announcements. Online, you're not going to be able to unmute yourself so we can hear you, but if there is someone who would like to request that you be promoted to a panelist, so that way you can address the group, if you will please email Rachel Fenn, and I'm going to give you her email address. And so if you will email your request, and then Judge Gotts and I will figure out whether to promote you at that point. So her email address is rfenn, so RFENN, at courts, which is plural, .az.gov. So rfenn at courts.az.gov. And with that, I'll go ahead and turn it over to Judge Goss.
And I want to thank everyone for being here. So that folks, if you saw the agenda, you saw this, we're not going to be taking public comment. So if you have questions that you say, hey, could we ask this or could we address this? You're welcome to send those to the RFEN email address as well. But what we wanted to do, and the purpose of this meeting, is to really have and I understand parents are stakeholders, so please don't take this as anything other than that. But the folks who represent the parents and the children in these matters and the AG to begin a dialogue and really get a focused dialogue to move forward. Couple of housekeeping. Generally, folks are not allowed to record these kinds of proceedings. One person did make a request beforehand, and that person has permission to record. That person cannot get up, move around, can't disrupt the proceedings in recording it, but can certainly hold up that. We are going to record this, so you are going to be able to view this. We will post it. So if you're concerned, oh, I want to be able to look back at this, you will be able to do that. That'll be posted on, I'm not sure which website for certain, but very possibly the Court of Appeals, YouTube, and the Supreme Court's site where you may have found the agenda and other things. Second piece, this is a really complicated issue. This is an issue that has been a struggle for people since we began moving forward with penalties and terminations. My own history, I sat on the juvenile court. I have been in these hearings. I have granted and I have denied requests to set penalties, to terminate. I have dealt with a lot of issues. I worked with juvenile victims of sex trafficking to try and help get them the help they needed. So I have that background and insight. I have lived through this process for folks. I understand some of the frustration. And I understand there may be 30 years of pent-up frustration. What I'm going to ask is people remain calm, because we have a different setting right now. There has been in the past, and I'm not speaking out of turn, to say some resistance to some disclosure. And that is what it was, and it is in the past. We have a new administration, a new agency, a new AG. And I'm not being critical of the people in the past. There is something they were doing, but at this point, what we're trying to do is figure out how to make sure the disclosure does happen, that these documents are produced timely, so that parents have a meaningful hearing, so that the judges get the information they need to make the decisions, and how we do that. About 16 months ago, 14, 15 months ago, the guardian issue arose. The guardian issue is the guardian system was going to be explained, but by 50,000 foot view, it's the system that is used by the department to assess cases for their caseworkers to handle things. It's also a system through which disclosure passes, at least some. The challenge is it wasn't designed to do that. It was designed to have some silos. Those silos have created a problem. They're not easily moved into a disclosure system. Case notes have come up as one of those areas that has been a challenge. So we are trying, and folks are trying to get that straightened out. So I think the news here is the messenger is different. So be careful about shooting the messenger, listen to the messenger, and figure out where we can go. what I'm hoping, and I think I speak with Judge Starring and Judge Young, is perhaps today we don't have a full answer, but that we are in a place that we start to move forward, that we have a plan, we have timing, we have deliverables on when these are going to happen, because I can't flip a switch and make disclosure happen yesterday or even tomorrow. And nobody's capable of doing that, but it also needs to be moving along. The one concern that I think everyone has is the speed. And I'm going to say that I think it's a concern on both sides, that this is taking longer than folks thought. So as we go through this, listen to what each other is saying. If we need to schedule more meetings, we will. But this is the first step, I think, in getting us to a position where we can move forward. Why am I involved as the Chief Judge at the Court of Appeals? And this is because I've at this point stayed about 100 cases in which I can't have assurances that my judges are dealing with a case in which full disclosure happened and that isn't going to be subject to some sort of collateral attack. And we made the decision that this needs to be addressed first, rather than run the risk that, for example, processes keep moving, children move forward towards adoption or get adopted, and we find out that something should have been disclosed wasn't, and it was meaningful. So that is why I'm involved. I get at my court the bulk of the appeals that come from them, and that is from Maricopa County. So I think Maricopa County is the other focus of this and maybe the more challenging area. And so I think that's part of why folks need to be listening in how we're going to do this moving forward. So we did publish an agenda. I will just remind folks of if you want to be promoted to a panelist, and for example, Judge Starring will be a panelist because he is one of the folks here. We're not going to promote panelists otherwise. We have 2 people or 3 people who have been designated to speak today. It doesn't mean they're the only ones, but to at least for format and for approaching the agenda, this is what we've done. We're going to hear from Katie Patak first. And I know that's not your official name. Is it okay to call you Katie? Okay. Katie Patak with the department. She's going to show what Guardian does, just so folks can see that it's not a black box. There's things that it does and things it doesn't do, and walk through that. Then we're going to hear from Kirsten Wright. Kirsten is the division chief at the Attorney General's office who has been working with this. A commendation again on this. This is not a new problem. It's been existing. I do want to commend BAG for saying, wait, there's something not happening here that should. Kirsten has represented parents in the past, so she has a deeper understanding of some of these issues and brought it forward. That took courage. I mean, that we should acknowledge that. Now we're at the point of, okay, what's the next step? How do we stand up and fix something, right a ship that wasn't right? So that's what we're working towards. So Kirsten will go next, and then George Foster, who's from the Office of Legal Defender here in Maricopa County, who has been talking with folks, who has been a juvenile court judge in the past, is currently working with Parents Council and Children's Council, is going to talk and address some of the issues and the concerns on that side. And then we'll go forward from there. Going through, we're going to talk about how we can make disclosure more efficient from the AG side, and what the Office of Legal Defender and other parents' attorneys are looking for and what we need to do to make this effective. Potential procedural changes. And I know, I'm not certain we're going to get into it today. And again, this is not a committee meeting. We're not going to make recommendations to somebody in that regard, traditional. But I know some concern has been expressed about the 10-day requirement for disclosure. You know, maybe that applies in the last 45 days of it before a hearing, but maybe that doesn't apply. It doesn't exist in other settings. Maybe that's something that we need to look at to make sure we're effective and can do what we say we're going to do and actually follow the rules. If you set a rule that nobody can follow, then it's not an effective thing. So it may be something we need to look at and have a discussion about. And so then the other thing is, I just mentioned a special action program that we have going on here at the court in about 2 weeks, because that may become more important because of the dependencies, the recent opinion, GK, in which mootness became an issue because dependency decisions are reaffirmed so often that the old one that's being appealed becomes moot before we ever have a chance to act on it. Which means people don't get a full fair opportunity to have that dependency finding heard. So we're very focused on it. I have a committee that I have working on it, and curious to hear from other folks about that, and certainly if that special action thing can also be brought up. So with that, I'm going to get things started by asking Judge Starring, is there anything you want to add? He's not? Okay, that's all right. He had other meetings today and I know he wasn't able to be here. So what I'll do then is just go ahead and I'm going to begin with Katie Peck, who's going to go through and show you what Guardian looks like. How it happens when somebody sits down at their computer at DCS and opens this system. It's a test model. You're not seeing confidential information. What you're seeing is just a model that they use that she can use to show you how it works and why some things are a challenge. That doesn't answer the question of disclosure, but it at least lets you see what they're doing.
Thank you. And thank you very much for the setting of the scene. I really appreciate the thought put into that because we agree. I think everybody here wants the same thing. We want kids safely with their parents. If they can't be there, we want them safely with their family or, you know, a family-like setting. And so we want to make sure we're able to get you all what you need to make the right decisions in a way that we can actually do it. So I appreciate that. I'm going to share. And like Judge said, this is a fake case. It's not a real case. And so there's going to be a little bit less information than what would be in a normal case, but you'll get the gist of it. So I always like to start with the person. This person is in Guardian as a caregiver. And then this is what you can see. And part of what I would like feedback on is a lot of this they're screens. So they're not documents, right? And so when it comes to the disclosure rule says anything that's a document, you have to disclose, you know, created within 10 days. But how does that apply to like an information input into a system? And so any of these kinds of things, for the most part, if people want it, we're having to like, at this point, screenshot basically the page and then disclose it that way. But the issue is a lot of this information you're getting in the court report, you're getting it other ways. So, you know, a lot of this auto populates into a court report. And so what do you actually need versus what, you know, you're getting through information. So you can see here, we're now getting pictures. I see a lot of pictures of children. In here, you have contact information, any addresses we would have for this person, phone numbers. If we've had previous history with them, dates of birth, AKAs, all those kind of things. So that's what a person screen looks like. The prior history here is not super filled out, but here's what you would see normally. So prior intakes, an intake is going to be a call to the hotline. So I will show you in a minute. I can find it a different way, but normally you could click on here on the intake, and then it's going to say report. If it met report criteria, you can read the narrative. You can see called in. It could be a screened out report. So it's an allegation that didn't need abuse or neglect. It could be an AWOL, medical consent. Like there's some different things, status communication, like I need the case manager to call me, like those kind of things. The next one is assessment. So an assessment is an investigation. So anything that on the top one met report criteria, then you have an investigation. I'll show you an assessment again in a minute, but then you click on that, there's some information underneath there, and then you get into the case. So a case means there was a removal and there's going to be a dependency filed. Underneath here, if we ran a DPS check, you can see it on this person. Obviously, we don't disclose that. That information is confidential given our agreement with the PS. Notes and documents, you'll find these under the assessment and under the case. So normally you're not going to see anything here. And same thing with plans. So those are specific to either the assessment or the case. So for the most part, there's nothing underneath these. I find legal is helpful because if we need to know, has this person had their kids removed? Has this person had their rights terminated in the past? If we go over here under legal status, you could see like dependency found as to child, rights terminated as to child, adopted child, whatever. You can see all of that under the legal status. And then If they're a child, so this wouldn't be for an adult, but if they're a child, there's sometimes education information in here, like if they have an IEP, do they have special needs? Where do they go to school? If there's an IEP, they can list the document, underneath here. But it should also show underneath the documents in the case. Basically where they go to school, where they, whatever. And then the same thing with health. Honestly, I haven't seen these filled out, that often in cases. Every once in a while you'll see stuff in there, but for the most part, there's not a ton of information in there. But a lot of this stuff is gonna pull in other ways, like it'll be in the court report or it'll be, disclosed through other ways. So these are all the things that are under a person tab. So I'm gonna go back to the prior history so you can look at what a case looks like. So I'm gonna click on this, this guy. This is dad. Here's his case. It's thinking. And then here you can see where the assessment, you can see there was an assessment. I don't know why it's not showing in the other one because it's a test. And then you can see like the intake. So if I click on this intake here, this is what the screen would have looked like. So if somebody says like, oh, well, what were the allegations? So here you can see it was a phone call to the hotline. This one has an anonymous reporting source. You can click on the narrative here and it will, normally here it would say what the allegations are, right? This is what the call came into the hotline and whatever. You can then see the disposition. So if it was taken as a report, where it was assigned. So this is the unit it was assigned to. If it's criminal conduct, it went to OCWI. And those are kind of like the main things that I would look for in an intake. And I don't believe, and correct me if I'm wrong, I don't believe the intake narrative is generally disclosed. I think it's in the court report. Is that right? Okay. But that's something that you can easily run as a report. So that's not an issue if people are interested in that. So we're back to the case. So you can look under case persons. These are all the people associated with the case. Here's all his kids. Collateral might be like a roommate. Participant is probably mom. Yeah, then there's him. So these are all the people that are in the case. Service requests, I think, has come up recently. People want to see service requests. We can run a report on these. So you can open it up and, like screenshot this actual screen. As far as like what's in the service request, or another easier way to do it is we can run a report if everybody is like agreeable to this. Where I can export all of this into Excel. So then Excel is just going to show you. I don't know why it's doing that. Oh, because I didn't click it. So if I want to like run a report of all of the service authorizations, we can do that fairly easily. Because I guess sometimes this becomes an issue, but I don't think this is something that we generally, like, as a matter of course, open up. It's thinking, okay, so this is what it would show, like the request date, if it's open, draft means it never went through, so they like started it but didn't finish it. I don't know, some of these are closed, pending approval.
And what's showing on your screen is not
Oh,
up there.
sorry.
For
Okay.
some, it's probably because of how the share screen works.
I don't know how to fix that. Hang on. Let's see.
If you do stop sharing and
Stop
then-
share and then share this.
And then
page.
share this one.
Sorry. You would think by now. I would know
That's
how to
all right.
do that. Okay, so, here is what, okay. So this is what I was talking about, the Excel.
There it is.
There it is. So you can see the service request, the name of the request. So, we're looking to put them in this foster home. The license placement, the date of the request, it's still open. It might show closed. These are training. So this is a report we could run if people need it. The ones that go through, so the ones that say open they auto-populate into the court report. So if you're like, well, what's in the court report is enough on a day-to-day basis, but then there's some argument about, did you put in this referral, did you not, and it comes into issue, we could at that point do it if everybody says, okay, we're fine with what's in the court report. Which is what I would
And just a
suggest.
question.
Yeah.
And this will come up, but It may be that it starts with very quickly, the list could be generated and sent to people and disclosed with the down the road deliverable maybe in 6 months, that we move to the point of being able to just fully disclose. And so maybe we have to think about that if that's what we need to do, to make sure the disclosure happens, folks know what's there. If it can't all be done at once. So this is an example of what I was saying, maybe it has to be staged. Maybe because we can get that list out to people pretty quickly, but it would take a lot longer in every case to get every document. That we recognize down the road, folks need every document, but we use the list as an interim fix, so people at least know what's in that system. I just throw that in as a way, some of the thoughts that I want people to be thinking about. What do we do today versus what do we do and have planned for 6 months, so that we're not waiting 6 months to get everything we want, and sacrifice the good for the perfect in the meantime.
Well, and I think there's also, we want to think through, like, if I'm typing in, I want the surface authorization, is that the creation of the document? Or is the creation of the document when I run this report? And so if it's information that you all need, right, we want to get you what you need. But as far as within the 10 days, because this too is not going to change every 10 days, right? I mean, you put in a service authorization that, it's not happening every single day in a case. And the same thing like with case persons, if we screenshot this at the beginning of the case, it's unlikely that it's going to change, right? As the case progresses, because unless a baby's born, or you know what I mean? Like the case people are not changing frequently. This I think is what everybody cares about. So this is a case note. So if I click on the case note, these are often like parent contact, child contact, those kind of things. So this would say over here where it says test note, it would say parent contact, the date, the time, the location if they have it, and then basically a recap of the conversation that they had with the parent or the child. Placement of whoever it was. Documents. So documents, if you did not hear, we can now kind of bundle these and disclose them quickly. This 10-day disclosure thing is what it looks like when we bundle them. So you'll see there's different things here, like you could see the presentation plan here, the family functioning assessment was created as a document and it's listed as a document. So what the field worker can do is they can select, okay, in the past week or whatever, I created these 2 documents or they were sent to me. And then I'm going to run that, which I'm pretending, right? And so I'm going to run that as a disclosure packet. And then that's going to either get sent to CRCU if you're in Maricopa County for disclosure, or I'll give it to my case aide, or I'll do it myself, or however that works. So the way these packets work when you look at them is that, so when you should be able to, when you're in here, and I looked at one of these previously, and I don't remember if it was this one. It will tell you, it wasn't this one. It will tell you which documents are in the packet. So that way you can know, oh, okay, I disclosed this document on this date and it's in there. The family functioning assessment, I talked about this. This is the one when it's done, the case manager should be converting it to a document and putting it in here. If you aren't seeing those, let me know, because those are things that you absolutely need to have. Same thing over here with the case plan. The case plan that can convert into a document and disclose the regular way. Yes.
I'm going to back up a second for folks to understand. When you say it'll show that you disclosed it, the caseworker has at that point clicked on it. Is it going to the CRCU at that point, or is it going straight into a disclosure? Could you walk through that?
Yeah, so I'll show you actually.
Okay.
So we have this report, and sorry if people have already seen this, so I'm gonna go through it quickly. So you can do it in particular status. So like you can see there's no packet. So no packet means this document requires disclosure, or it's a document, right? Like the system can't decide, oh, this is a financial document, it doesn't need to disclose, but it's something that is a document that the case manager needs to look at. Pending and pending task means that they have created the packet that I just talked about. And then when either they or CRCU discloses it, it will change to disclosed status. So you can tell the difference between, and then this tool, this is like a supervision tool that this is a unit in Pima County. So if I'm the supervisor, I'm like, okay, in September, there were 10 documents that arguably should be disclosed that weren't. So that's the conversation I'm having with my staff of what's up with these documents.
So let's say your staff says, oh, this is financial, this document, it doesn't need to be disclosed.
Yes.
In, you know, the civil litigation, it's sort of like a privilege law, right? There's confidential information here, we're not going to give it to you. Can you and will you give a list of, these are the documents we didn't disclose? It's a financial data, bank data, because I think that's part of it. What is it that you're not disclosing, and how do I know that you didn't miss a document?
Yeah. So that came up at COJC, and this, right now, no, we cannot do that. But the feedback I heard was that they're really interested in that, because if I'm a manager and I'm seeing 5 documents weren't disclosed, I don't know if it's because they didn't need to be disclosed, or if it's because my person was on vacation and came back and it's fine. You know what I mean? So the feedback I heard was it would be nice to have a status basically that is like, doesn't require disclosure, attorney-client privilege, or whatever, you know what I mean? And then as a manager, I can say, okay, well, whatever. I can't promise that's possible, but I can take it back, you know, to our IT team for sure. Then have that conversation with them. Oh, also this one, so this is interesting, too, and I don't think, again, this is something people need within every 10 days, but like, we can run a report of like, and I tried this on a real case and it works, but like, when a kid was in a placement, like where they were in placements, because sometimes, you know, these kids that have been in a lot of placements, I want a history of where they've been, and I want to look at the dates they were there and whatever. So that's something that we are able to create. And that's pretty much it, like, as far as like what's in a case. So those are the things, I think the things we 100% agree, the documents with very few exceptions. Like we were talking about a financial document. So sometimes like a provider will send a bill, you know what I mean? And like, that shouldn't be, that's not case related. Pretty much everything else, case related documents, have to be disclosed. We are wrapping in the notes, to also go into this packet, which between the 2 of those and what auto generates into the court report, I think that gives you a very good picture of what's in here. The other thing I did want to tell you all, so we put out an administrative directive. I think in the past, there used to be hard files, and I think people still keep hard files. They are not to keep hard files. The law says every case-related document has to be in Guardian. So we reminded staff, every case-related document needs to go into Guardian. Then you can easily disclose it through this packet disclosure process, and we're not having this back and forth about like, well, that's not a document we disclose. That's a document we do disclose. Like, if it's a document, it goes into Guardian, it gets disclosed, right? And then we're not having these kind of like historical, well, we never did this before and we never did that before. The other piece, I know everybody wants to talk about emails. So we put the administrative directive, told staff, you have to case note emails. I think there's an argument that if you send the email, the parent has the email. You know, disclosure obligations apply to everyone, not just the department. So I think that, you know, there's an argument they have it. I know what Bill's gonna say is that the child's attorney doesn't have it, right? Just because the kid has it, or sorry, just because the parent has it. So that's why we're asking the case managers to case note these. They can also print it and upload it as a document if there are thoughts about that. The final piece is text messaging. Everyone is very mad about this. I know, we don't have at the moment the technological technological way to pull text messages. Our IT team has found several solutions that they're looking at. They're expensive upfront. They're expensive in the long term because you have to pay to like store all of this. So we're kind of exploring what the best option for that is. But it's not an immediate fix either, because what it does is it stores them to a cloud, which still requires the case manager to pull it down. So we have told staff not to be texting until we come up with a solution. We know that's how parents like to communicate often. We know that's how young people like to communicate often, is through text. So it's not ideal. We know they're still going to do it. So we've told them, if you receive a text, if you send a text, it needs to be case noted, right? So that's our kind of, you know, like a don't do it, but we know you're going to do it. But make sure you're documenting it. And then I think it will be a quick solution because they have some already that, we reached out to other states. I appreciate you saying we reached out to every state. We are the only state in the nation with mandatory ongoing disclosure obligations because we wanted to say like, how did you figure this out? And no one has it, so no one can help us. And in fact, they were floored that this was our rule. Some states have like after 30 days, you have to, give XYZ documents, but for ongoing, it's on the parents' attorneys or the child's attorneys to request what they want. That's not what we're asking for at all here, but it is unique. But some of them had some ideas of how they do the tech solution, so we're exploring those.
Does anybody have any in the room here, questions that they have? Folks that were invited? Not seeing, yeah, go ahead.
Just briefly on one of the issues, the summary form we're talking about service providers.
Yeah.
And the referral dates and things like that. Can you explain the difference between what's in the referral, if you were to print out a referral sheet versus what's on the summary? I'm assuming it's extremely limited, the summary is, versus what's actually in that sheet itself.
So I think it's basically the same. Let's see if I can open one. It says this is test. I don't know if it's gonna actually like pull up. So you can see the service request here. Its placement. So all of this stuff was in, I'm looking on the left-hand side under request details. All of that was in what I pulled up. It doesn't have, at least from what I'm looking at, that it was an emergency or initial like type of placement and why the placement is needed, or if it was court ordered. I don't know what this means. Option. Let me, I'll see if I can find some like real ones and I'll look at the two and see what the difference is. Cause I think what the field would say is that like the relevant information is pulled into the court report, but I'll look at both of them and see what's missing. Sorry, go ahead.
And I mean, the only thing I would say is, I mean, we can argue, forward to the base in terms of what I think is relevant versus what a case manager, and no offense to a case manager who's maybe, 3 days out of college. And so, you're going to hear the same thing from all parents council. We want all of it. And so it's really hard for me to know, if I get a summary, and there are issues with services, not only just the dates, but the type of information that's relayed to, was put into the summary. So I would be curious. I know that that's an issue. I can tell you that just from where I sit, having talked to a lot of attorneys that do this stuff, that they're going to want all of it anyway. And we're going to want all of it within 10 days because that's the right now. But if there was some way that it made it easier for you to create those documents that provided all of that information, I don't know if there is, then I'd be willing to listen to that. But I would want to see probably lots of the referral sheets, if we're talking about that one issue, the referral sheets and the summaries to see what's just in general, in real cases, what's in there that I would want. Emergencies, court order, was it court order? Is that the problem that we're having? Whatever.
Well, and the one thing I'll say to a comment you made about the case manager deciding, the point, like what I hope to get out of this is to give guidance to the field. So they aren't choosing. I'm telling them, or, the group has decided you have to do each individual or the summary is fine unless something is contested, or you know what I mean? Like I want to tell them, are your expectations when it comes to disclosure with something that everybody can kind of live with. So let me look at a couple of them and I'll tell you.
And Katie, just for clarification, what the total document would be for the referral would actually be a screenshot of this screen, correct? So it isn't a separate document that gets created that says all of everything. It's a screenshot of these fields. So I think there's some confusion that you submit a referral and it creates this one piece of paper that has everything nicely written like a form, and it isn't. It's actually a screenshot of what they have entered, put into the computer system, then they hit enter and it's sent electronically. So there's a difference between being able to hit print and just print everything and then actually having to create something that didn't exist before.
Right.
Where if we can run that report that shows everybody, these are all of the referrals that went in, and you say, okay, I see all of these referrals, but I'm actually really concerned about number 3. Could you send me the screenshot of number 3? I think that would be a way to move forward that isn't overwhelming for the case managers having to go in and screenshot 35 separate pages and creating a PDF to be able to.
And the only thing I can say is, as we sit here today, the issue is today that we have rules that, you have a 10-day disclosure. I understand you're struggling with that. We're entitled to that. So that's really going to be what we're up against. I'm entitled to all relevant information, and however the system is created and what it's able to print or not able to print, and I'm not your IT guy and I can't fix it, but I want the relevant information. And I don't know, whether the fields you guys have in Guardian for those specific screenshots for the summaries are going to be enough anyway. I mean, there could be missing a ton of relevant information that I don't have. And so again, it's difficult sitting from where I sit to know what's in there, without really having access to that. I'm never going to get that.
Let me ask a question. George, did you want to go first? Judge Ross?
Yeah, if I could just interject, we do have rules governing this. Fortunately, there is a silver procedure. The whole separate section of electronically stored information. Okay. And whether or not that's going to work in this context, as I sit here, I don't know. But if I'm understanding what's happening, with respect to referrals, you're generating referrals electronically only. There's never in paper.
Yeah.
Is that correct? Okay. And so I appreciate, having going there and generate a screenshot of all this stuff. And maybe that's what the rule requires. And like I said, as I sit here, I don't know that. I do know that you're required to at least make it available. And so perhaps there's some middle ground that can work there when viewing that particular vision to see if it's workable with your system. Because I stopped practicing before electronic.
And the rule was written before.
Well, what I was going to say is it may be, this is the step. We're headed towards getting this so that it's produced. And one thing that, most of us grew up in the world of a referral was a letter. It was a hard copy of a letter. It was in a hard file. The referrals don't look the same. They're fundamentally different, but the information that's provided is still something that folks want to see. What did caseworkers say when they sent this over? And so possibly it's we can give you this today, and we can make that pretty efficient. And then we keep working again, see if we stage it to get to the level that it should be.
And I think we kind of get caught up in language and have a misunderstanding. When you say there's a summary of the referral, if what you're telling me, the referral, the summary is going to give you everything that's in your document, in your electronically stored information. I wouldn't call that a summary. Okay. I say, here's the referral, and here's the format that it's in.
Right.
Because, when we hear it's only a summary, well, that must mean something's missing.
Yeah. Well,
If the summary is not missing anything, then we don't have efficiency. But if the summary does exclude information that on our side, we may feel is, and that's the problem.
well, and I think to Bill's point, if there are things in here that you all want, like, for example, was there a court order? Like, we could potentially, and I am also not our IT people, so I'm saying this with a caveat. I would think you could build the report to just say, pull every single field, right? And so you're getting it in an Excel spreadsheet, but it's every single data point that would be in the screenshot, right? So I think there's a way to get, I think, like you said, I think there's a way to get what you all want in a way that works for us. But I'll put it on that's on my to-do list.
Is there anything else before I think we move to Ms. Wright? And Ms. Wright, again, is going to be talking a little more generally about the history and how we got to where we are today and where we are today.
So, hello, everybody. I just wanted to, I'm sure everyone knows that historically there have been some documents that have not been traditionally disclosed. We've had a lot of internal conversations with regard to changing both the technology and the culture of the department. And one of the, I think, historical issues with the department is there was a culture that said, if we created this, it's an internal document and it stays with us. That is a really hard culture to break. So we have case managers and supervisors and PMs who have been with the department for decades. And trying to slowly change that culture has been somewhat difficult, but the way that we've attacked it is from the top. The department is issuing administrative orders, internally saying this is what you have to do. Then from the bottom, from the Attorney General's office side, we have all of our trial attorneys who work directly with the case managers, reminding the case managers, everything means everything. We need to make sure all of this is disclosed. Hey, I'm not seeing it. Case notes in what you sent over. Can you make sure your case notes get out? I didn't see an FFA come along. We need to have that disclosed. So we're trying from our end to sort of re-educate the case managers. We have a lot of brand new case managers who are feeling very overwhelmed with their jobs and they're just learning. So we're trying to help. This is now the status quo. This is what you have to do. And we're hoping that we eventually meet in the middle and we change that culture. There are 2,000 case managers at the department. That's a lot of change that needs to take place. So I know a lot of people are wondering why we're 15 months into this and we haven't seen dramatic changes. And that's part of the reason is that that desire to really change the way the department handles the situation and how they move forward. Just to give you some updates in Guardian, they have done a lot of technological changes since this issue was discovered. So in September, phase 1 was completed, and that entailed having 3 different technological sort of fixes go into place. So the way that it worked before is that a document from a provider came into the portal and sat there until the case manager went in, reviewed it, pulled it out of the portal and put it into a case. And that's why we ended up having all of those documents in the portal, as there were case managers who weren't doing that consistently. Now, the first change the department made was to make sure that those documents are automatically moved into a case. So the case manager no longer goes into the portal. They come into the portal with an ID number and they get attached to that ID number, which is a person in the Guardian system.
So I'll take you off track for just a moment.
Certainly.
And what happens when a case comes in without an ID, or it's a document comes in without an ID number or something?
So go ahead and.
I will
explain
answer
That's-
that. So that can't happen because it has to be associated with a service referral. So that's how the provider gets paid. So we put in the service referral that I showed you, then it's associated with the case. So if I'm the provider, I can't just like put a document in Guardian. I have to give it to a person who is associated with the service referral. So I think there was some confusion and maybe it was my fault because I said there are like ghost people in Guardian and they're like profiles that maybe were old from Childs and got moved over. They're not real people. You cannot associate documents with those people because there has to be a service referral in place. So it has to be an open case.
And so if, for example, someone tries to put it in, it just gets rejected and they have to go back and fix it.
And I did ask about like, what if I give it to Jane Doe, but it's this Jane Doe, not that Jane Doe? So the case manager themselves can't move it, but they, in every office, they have someone called a program specialist. They're kind of like I don't call them a know-it-all, but they're like somebody who's been there for a while. They know, how stuff works. They will put in a ticket to IT, who then will move it to the correct case. So that's how we fix that issue.
So at that point in time, that very first phase, then the documents could be grabbed by the case managers and put into these packets to be sent to CRCU or disclosed in the outer line counties. Those were the only items early on that were able to be put into these packets and fairly easily sent out for disclosure. Since that time, phase 1's completion, we now have safety plans are able to be pulled into packets, family functioning assessments, custody notices, infant care plans, case plans, and transition plans. All of those items can now be clicked and moved into a disclosure packet and sent off to CRCU or emailed out to the parties if you're in one of the other counties besides Maricopa. That completed phase 1. Phase 2 is going to make it easy for the case managers to disclose their case notes. The only way that they can disclose case notes at this point in time is pulling case notes into what's called a report. And the reports are all Excel spreadsheets. So what would be sent out is an Excel spreadsheet, and then the case note would be the cell.
They can do it. They can pull it into a PDF. They can do it both ways.
Oh, okay.
Yeah, sorry.
I
Sorry. Yeah,
apologize for that.
that's okay.
So they have to create something with the case
Right.
notes. They can't just click case notes and hit send like they can with the other documents. But phase 2, which should be in place by January 1st of 2025, will give them the ability to take those case notes and create a document that will be sent out to CRCU or sent out much more easily. So they are,
What I'm hearing, just to make clear, that means hopefully by January 1st, that this is accomplished, that means emails will be in the case notes as well, based on the administrative order.
Yes. And we're sorry, I think, hopefully people are starting to see that the emails are being moved into the case notes. Just to give you an idea of the volume that we're talking about, just last month in September, 80,000 case notes were created by the department. So this is a large number of documents that are created each month by the case managers with regard to, their efforts on the case. When they're speaking to someone, if they're talking to a provider or a parent or a child, all of those should be going into the case notes. So the volume of the case notes is pretty extraordinary. We're hoping that they'll be able to get those into those documents and send out so that all council has those documents, has those case notes. Just so that you know what the department has done, there was a backlog in CRCU that was several months. The department hired an outside agency to do all of the redaction for that. So they sent a little over, I think it was 8,500 documents out to this redaction agency. They redacted all of those documents and have sent them back to the department. CRCU is uploading all of those to Jax. So CRCU is now pretty much current. Their goal is that when a case manager sends them a packet for disclosure, that packet should be disclosed within 5 days. That is their goal. I'm sure that sometimes might fluctuate by a day or two, depending upon the volume that's coming in. We have cases when there's perhaps a medical issue with a child and you might get thousands of pages. And so getting a couple of those cases in a row may slow CRCU down a little bit, but that their goal is within 5 days of receiving the packets. I do want to just mention there's a national community of practice for child welfare agency attorneys. And it is AGs, and in some states, they're county attorneys, and it's a wonderful group, and they represent all 50 states. And Andy Kawamaro, our section chief, and Emily Steiner, who's deputy general counsel for the department, asked if they could sort of run the meeting last month to ask questions about disclosure and how disclosure is completed in other states. And it was really interesting to see the response from the other AGs and county attorneys nationwide. They were all shocked that this disclosure is 100% disclosure obligation and that it's within 10 days. So listening to them, there were a lot of very interesting ways that they handle it. And so, we have done a lot of talking with the department. And one of the things I'd like us to discuss later on is some of these potential solutions that the other attorneys came up with of how other states are handling the volume of disclosure and how difficult that can be to ensure that parents and children have all of their documents. And one thing I just really want to make clear is, as Judge Goss said, I represent parents and children. I understand the need for that. And I know how frustrating it is to say, my client says they've gone here and I have not one single record for that. Where is it? We get it. We are really, really trying to make a difference here and to make sure that the department's in compliance. The department has been wonderful to work with and has been very transparent and want to make the changes that they can make so that everybody has all of the documents. So we are looking forward to this conversation and hope that we can come to some sort of agreement as to what's really needed, what is relevant, what can we get to very quickly, and perhaps, are there ways that we can get some other disclosures out in other ways that might not be within the 10 days, and that might be asking for some rule changes or some changes to the statutes. But we appreciate that everybody is here, and we appreciate your input. We certainly appreciate the courts setting this up for everyone.
A question about, before I open up for other people and certain other questions, but you mentioned that CRCU has a 5-day now compliance disclosure requirement. One, is there a plan if they start to get behind that? Because it starts at 5 days and then we slip to 15 and then suddenly we're 5 months behind again. So that's first. And then case manager compliance for getting those documents to CRCU, because there's 2 places it can get clogged up here. It can stop because the case manager just doesn't do it, or get stopped because CRCU gets backed up.
And I'll let Katie answer those.
So for the first question, yes, we are keeping an eye on it. We use that disclosure firm for the big chunk of them. That's a law firm and they were very pricey because we did it quickly. So there are some in-state redaction firms that we have met with. And so if we need to If we notice they're getting backed up and we need to contract some of it out, we are keeping a close eye on that. The second issue, so that report I showed you, it's called a Power BI. You can filter that by region, you can filter it by unit. So if I'm a supervisor, I can look exactly at my unit and see how many documents are outstanding, and I can even go down and see what the documents are. So I can see each individual document, who it belongs to and what the status is. And those are conversations they should be having on their weekly accountability meetings. They should be talking about in their case plan staffings and their one-on-ones, like that's, and I know that the PA, so there's like 5 regions, they oversee the regions. This is on their weekly accountability calls as they're talking about the disclosure BI. So that's how we're keeping an eye on it from the field, but
Is the top down looking, for example, I would, the person at the top can sit there and go, okay, everything seems this, these are the documents, wait a second, this unit.
Yep.
Has a lot, is this, because that can happen, as you mentioned, with culture at any level.
Yep.
So just, is that being monitored to make
Yes.
sure we don't run awry?
so that's one of the things they're monitoring. And not problem, but the limitation right now is it only looks at documents. So it doesn't look at the case notes, but it will. So, but yes, that is something, the expectation is that they are talking about this.
And
on a
that's,
weekly
the
basis.
case notes, just the January 1st deadline.
And it just, if I may, just with regard to the technology, I know, I'm sure some people are thinking, why can't you just fix Guardian and make it work? So it was created by Microsoft. Microsoft, was not able to fix some of the issues, so the department has now contracted with IBM. IBM has come in and they are trying to work on solutions to that. But, code has to be written, then there's a testing period, and then, you move forward to see that if everything's working the way you think it's supposed to be working, and there are little code fixes that need to go in there. So that's part of the slowness of this, is just the technology piece of it. And so, we've asked for, the department has asked for really hard deadline dates from IBM to make sure that they're in compliance. And that's where we get that January 1st date for case notes, is that's the date that they've been provided with.
So just, I think from the other side of this, courts go through document changes too, and we do all the testing. But no one would be happy if we said, we're not going to accept any new filings for 6 months, and we're not going to send out any orders for 6 months because we're still testing the system. So I think part of it is you've got a plane that's flying. You're trying to fix the plane so it can go more on autopilot. But I think, what do we do in the meantime to keep that plane flying so that I don't have to look at Judge Bustamante and Judge Welty and say, hi, I know I've just said a lot of things and state them, but there were a lot of emails and case notes that never got disclosed in their cases. And until we make sure they don't make a difference, I have to hand them back. So what are we doing right now to deal with the case note issue, to deal with the, what emails they go in the case note, but then that's today. What about yesterday's emails?
So yesterday's emails can be put into case notes. And then the case notes can have that sort of Excel spreadsheet or other document that's created with the case notes in it. So they're just doing that more timely version of creating the case notes and getting them out. The one issue that we have faced with regard to emails, currently the department can only access emails for case managers that have left the department for 60 days. At the end of 60 days, those emails aren't there. Unless they're on a litigation hold. So if a litigation hold has been placed on a case, then those emails will stay in our accessible. So that is one sort of area. We may not be able to get some of the historical emails.
My question would be, what triggers a litigation hold? Because each of these caseworkers has cases which are in litigation. Generally, once it's in litigation, it would be on a litigation hold, at least in any other entity. I'll use an insurance, my background. An insurance claims adjuster, if they've got a case that's in litigation, their emails on a litigation hold at that point. Why wouldn't the caseworkers all have a litigation hold?
So we put them on a litigation hold when we're sued, like civilly. So if a parent is suing us for like an illegal removal or something, like a civil litigation suit, we are researching that issue, because I think when we went to say, can we pull these old emails? And they said, no, that was maybe news to some of us. So that's something that we're at the moment looking
And
to
it
do.
just, it's per department policy. So the department has a policy in place that that's how they handle that. So something that we're looking at is perhaps.
And I suspect we'll hear from some other folks about that. I
Yeah.
just wanted to make sure I understood and maybe other folks did, maybe laid up some foundation for you. Is there anything you want to add before I open it up to Bill or George?
Well, the only thing I'll say on that is that if the expectation is that the emails are case noted, it hopefully becomes a little bit irrelevant, you know what I mean? But
The reality is what you're saying is anything more than 60 days is just wrong.
If the case
If they
manager
have
has left,
experience.
If the case manager,
if the
right,
case
I
manager
understand.
has left.
And so they change an awful lot, and so I think that's,
And the same would be true with text messages because their phone gets turned off. They turn their phone back in, and so those text messages would most likely not be there. Caveat to that, and this obviously does not apply to children's counsel, so we understand that, is that the parent who's texting or who's emailing does have those documents. So that subject matter, I mean, they could certainly provide that to their, the disclosure rule is universal. They could certainly provide those emails and text messages to their attorneys to be disclosed as well. If the department no longer has those, because they would have received them from the department. We understand that obviously that leaves out children's counsel, which is a problem.
George?
Thank you, Gus. I guess I've been anointed with the task to speak on behalf of the Office of Legal Defender, Public Advocate, Legal Advocate, and Contract Counsel on this issue. And as Bill had mentioned a few moments ago, it's our position is that we want the discovery that the law says we're supposed to have. And we want it timely, we want it to be accurate, we want it to be complete. And if we don't get it, we like to have enforcement of those rules, because it's our clients' interests at stake. It's their due process rights to have these things. We don't want delay. When we had new judge orientation in juvenile, and he came in and said, we're 4 to 6 months behind on the current disclosure. It was like a bombshell. When you have a 90-day time frame for getting a case to trial, then somebody says, but you're not going to get the discovery before 6 months. That's the problem. And I don't think anyone disagrees. So all the things that we've heard about guardian, and I'm the biggest tech grunch there is. Tech people build systems that work for them and don't necessarily work for the customer. But what we can't understand on our side is, why would you build a system that can't comply with law? System
And I
doesn't
think it's
work,
a-
didn't resist or fix it.
I think that's a fair question. Unfortunately, there is that water under the bridge. It wasn't these
Absolutely.
folks that did
No,
it. And so I
understand
think,
But
it
moving
is
forward
true.
is.
yeah, but moving
is-
forward, the system needs to get fixed.
And can be. And I've
Yes.
heard today in little circles that they fixed a bunch of stuff, and I guess we talked about some of that, and that's dandy, and that's great. We unfortunately have a history where we had trials and it didn't work, guarded, and hopefully these fixes will work. But we also want to know, like I said, if they're not going to work, that our clients are not put behind the 8 ball as a result. That the children are not put behind. Because it's not fair. And it's not right. And there has to be accountability. You can't stop an entire system, court system, because you designed a disclosure system that doesn't work. For folks that have been around long enough to remember the Slack rules. Remember we talked about the Slack rules. Just
I
the
was a
Slack-
new lawyer when they came in.
Oh, yeah. And he hated having his name attached to it because every time he went to speak someplace, he had to explain what it meant. And he said, let me just state this simply. You gotta disclose everything. Whether it helps your case or hurts your case. Exceptions are attorney-client privilege and work done. This is that simple. Bob Myers wrote 2 lawyers, basically outlining, here's what the requirements are, here's what you're supposed to do. if you've grown up as a lawyer in the system, and this is how you practice law, then that's what you expect, and that's what we expect. And I'm not sure why we should expect anything else. As I indicated, I think what I learned here today, and I'll go back and tell about what happens here for DCS is that they've got a file management system that's totally electronic. And as I said, the rules for that, which would probably behoove us to take a real hard look at it and see if it works. And I think that we want to do that. But we have to know, for the purposes of getting our cases to trial in a timely manner, that we are going to be getting these. The biggest issue that we had was Kristen and all her candidates said to you, we have a cultural problem. And everybody said, well, what's that? Child said, what's that? She described that we have had staffers for a long time who've been doing things in certain ways and not disclosing things, and that's a bigger problem. She's talked about that here today. Here's what we as the defense bar don't know about that. We don't know what we don't know. She described today that any document that's produced internally is not something that we disclose. Well, if it has to do with one of our cases, I think that runs afoul of this. And number two, I guess the various categories of documents that were sent to me the other day, the large longer list of things. As I sit here today, I can't say how those may impact any cases or cases in particular. But what I do know is that any documents that are in-house, outside of the guardian system, that discusses our cases and things that are happening in our cases, are things that we believe we're entitled to see in order to properly prepare. You know, there are case notes, there's the parent contacts, there's the other contacts. And let me say something about email, because emails that are sent about cases aren't necessarily just between the case manager and the parent, or the case manager and the child's attorney. Child, remember, no. But they go to people at the referral agencies with all types of them. You have something go into Family Connections, and Family Connections say, well, we're going to refer this out further. And there's a bunch of email traffic about that. We don't see that. And we should. Because in a problem case, I'll give you an example. One of my attorneys was telling me that placement was making statements about the child's behaviors in the case that were totally contrary to the child's behaviors when the parents have a supervised institution. We only found out from the supervisor that the parent was making these things and they were looking for it. Well, why didn't somebody tell us that that was a problem to begin with? Because all we have is the SCA. But the replacement, foster placement, was reporting something else. Well, that could be important. Sure, it would be important to Bill in his practice and not to do. So the emails and other communications are not just the ones that go between the case managers and the client or the supervisor and the client, but across the board.
Case-related emails,
Exactly. Exactly.
of course, excluding emails to attorneys, things of work product.
Work product,
I,
attorney privilege, that's.
and in terms of ESI, electronic discovery issues. And I don't know if you folks have looked at that and how ESI works, because it is that everything is electronic now by requirement. So arguably pushes it into ESI discovery. And I don't know if you are prepared to talk about that today, maybe not. Certainly, again, I said I envision there to be at least several more meetings because we're going to try and set deliverables and come back and were they delivered and where are we getting to next? I think it's probably something both sides will need to look at and talk about maybe. Didn't mean to interrupt you.
One of my bugaboos, and this goes back to when I was sitting here. And if it's a rule that nobody's gonna do a darn thing about it, get rid of it. You got a rule that says 24 hours before preliminary petition hearing, there should be disclosure without documentation. It does not happen. It didn't happen in 1999. It didn't happen in 2007. It didn't happen last week. There's no miracle. Every now and then, way back, there would be some. And those were the days when I actually did temporary custody, because people had enough information to have a temporary custody. How many temporary custody hearings do you?
Not many.
How
Very
many?
rarely. I've done one in the last 12 months, I think.
And why is that? It's because the lawyers don't have the information to even make an intelligent decision whether or not to have it. I don't know what can be done as far as that's concerned. I know there's gotta be documents there, because otherwise you wouldn't file the case. Is it because it has to go through CRCU, which is another body? I don't know. But I do know that these are the things, these are the things that allow us to be able to properly prepare a case, so we can properly represent. Because that removal may have been, a little on the shaky side. Because after all, that initial affidavit only says it's probably the cost of leave. Not to say that this had to happen, this removal had to happen. Then we get to challenge it. And we can't, because we don't have anything. The other rules that say, 10 days after receipt, 30 days before trial, 10 days before an initial hearing. The frustration index that we have, and we have to dance around all kinds of things, is because we don't get it. And moving forward, we need to know there's something. I mean, your CRCU is what the law says that you have to do. Well, it doesn't say you have to. This is some case specialists. Ultimate responsibility. But we can't have the tail wagging the dog, or say that, well, because they do it differently in Arkansas, we should do it that way. This is Arizona. This is our culture. This is our legal practice. And to say we're going to move this all around because somebody's system doesn't. So we're getting a new system starting in December. No idea how it looks like. We too put notes into an electronic mail management system. But we also, in our system, have the opportunity to take that email and import it to that system. And so there's a PDF. I don't know if your system does that or not.
Working on is what I think we're.
Yeah, the AG system does that. No, I understand what you're talking about, but I don't think that right now Guardian does.
Why somebody didn't think of that, I don't know. Okay. But
Again, yeah, that's part of the problem, is some thought was not put into this, and now we're here.
But my point is this, we can't be coming back here every 4 or 5 years, every time somebody gets a new file management system, so now we gotta do it differently. We have to have consistency. I don't know what assurances we can get from DCS. Other than this, and I'm glad to hear, and Kirsten, we talked this morning, that there has to be a more collaborative effort at the school between the AG's office and DCS, and ultimately with us on the other side of the case. Because I've never heard of any law practice that places 95% of disclosure requirements on the client. Okay, the attorneys have the last word on, okay, if I didn't know what was being disclosed in the case, and I did complex commercial litigation, okay, I might be looking to pull my ticket. And I mean that. And if there was any question as to what could be disclosed or not disclosed, it goes to the attorney. And the attorney's got to say, the client may say, well, we don't want it. I'm sorry, you may not want it, but you have to. And that's another part of the culture of the agency that has long existed, unfortunately. Notwithstanding administrations as they change over the years. You've got a lot of people in middle management, they'll move, and that's tough. It's a tough game. I understand. But it has has to happen. It has to happen or we just, okay out. I've had judges say to me, Mr. Foster, I've ordered them to do this 5 times and they haven't done it. We've had a hearing. And DCS, did you do this? No. Why not? Just didn't do it. You can do this. No. Why not? Just didn't get it done. Why? Why didn't you get it? We just did. And this is just last year. And I felt sorry for the poor assistant AGs going to sit there and have to have the judge go through these questions. And then even at the end of the day, what was the remedy? I asked for dismissal. And you're not going to get an exclusion of evidence because everybody relies on that portion of the rule that says, because we take into consideration the best interest of the child in the genetic stage, so it must come in. And so what are our remedies are very limited, although I did find an interesting case where your division, the Court of Appeals, says strike pleading, you want attorneys. Unheard of in juvenile court. Heard of civil court. Juvenile court action is still a civil action. Like that doesn't get somebody's attention. In this particular case, the court awarded $268,000 in attorneys.
Somebody to pay attention.
That's to a government,
Yeah, against a government agency.
no, to a government agency.
I'm sorry.
I don't think you can pay it to a public defender. Can you be awarded to an agency? I'm asking, I don't know.
I think you can. I think there's a case that says I have somebody working.
I know if you look at the ADS case from my court, there was a review of the sanctions that could be imposed.
There's not a lot of utility moving money from one government entity.
Oh,
It's not-
absolutely.
It's not
Peter
practical.
Paul, it's all the
It's
same.
not practical.
What it does is gets attention and maybe gets some movement. There's that piece.
There's
The other part is,
There's arguably better ways to get it.
oh yeah, no, I know. I mean, it's like this.
And my
Well,
argument would be that it would take money away from the department's ability to provide care for those children. So
And that's been the argument. And then it's the first thing the judges say, when you ask them to not make ask with them. But we all know even that's not the case. It's not one order that's going to stop $200,000. So we just asked, we asked for some form of enforcement that has real teeth to it. Because if not, parents and children's rights will continue to be compromised. Our ability. And we can't have a system that moves under that model. So, those are the major concerns from the indigent, representation attorneys.
No, yeah, the only thing I would say is, having done this for a lot of years, and for many of us here that have been practicing juvenile court, disclosure is not, problems with disclosure from the department is nothing new. This has been an issue since I started practicing 30 years ago. So I appreciate the attempts by the department to continue to improve, how they get documents out of Guardian. Before Guardian, it was Child, it was another system. And there were documents that were stuck in Child. It was difficult to get those documents out. At the end of the day, my clients' parents don't care about the type of system they used to track, why you created it. Maybe for federal funding, other reasons, but at the end of the day, the law has been on disclosure has been consistent and clear for forever, really. My clients are entitled to those documents. Again, they don't care where it's stuck. They don't care who created it, whether you have the right IT people to fix it, why you allowed it to get off the ground in the first place. They don't care about the amount of money it takes to fix the disclosure issues. Do you have to hire an outside firm to do that? They don't care that CRC is taking 4 months They care about that. They don't care that you have to, you know, put several more people into CRCU and that you're able to get it done in 5 days now. At the end of the day, there's a responsibility that the department has had forever. And we're asking that, you know, that we pay attention to that and we don't lose sight of the fact that I get it. They're in a hole. People that are sitting here today have to deal with a problem that other people have created. That's just one piece of it. Guardian's one piece of it. Those are issues and those documents are there and they're accessible and you can print those. I mean, if you sit down, I think that and look at those documents, print them out and send them. They made, you know, statements, I believe yesterday, there's 11 people that are working, I think, on this backlog on the Court of Appeals cases, just those. Unfortunately, there are 11 people that are just doing it after they finish their normal job. And then they're letting them work, you know, I don't know what it is. Is it 2 hours a week or? I don't know what it is. Maybe it's more than that. And I don't care. My clients don't care. I mean, if they need to hire 50 people to get those documents done, it's 10 days is what it is. And so the fact that we can continue to limp through this, it's been 15 months and we've had, I think, one of those Court of Appeals cases finished 15 months that we've been really working on this problem. You know, the hammer has to drop somewhere. And again, it needs to go way faster than it's going. And maybe, again, we can talk all day about sanctions and it's something we talk about all the time. And maybe that's something that attorneys that do this work really need to focus on. And that the bench needs to take serious when we make those requests, because yeah, the money's coming from somewhere, but it does get people's attention. I don't want to do that either. But at the end of the day, if the response is, hey, we'll get there and it'll take us, you know, however many months, because this is what we have. Somebody needs to go to the governor, whoever else you need to go to request additional funds. Something needs to happen. It seems absurd to me that this has been going on for this long. And here we are again. And I really appreciate the fact that the Court of Appeals has taken it serious enough to have meetings on a regular basis to address this issue. But you know, from my side, I feel like I get a brain bleed every time I listen to another meeting, because it's just like, my clients don't care about any of process. And again, I appreciate what the department's doing and their efforts right now, but it really needs to speed up.
And that's why I wanted to hold this, to get a schedule, have it be not another 15 months. That's not an acceptable answer. And to make sure that we're all on the right track and that you folks can move forward. Part of the challenge of these cases is they're not like any other civil case, where striking a pleading is something you can do. You really can't do that in this. The courts have been pretty clear, our Supreme Court, the best interest of the children become an issue. But there are other things that need to happen, but it's also the reason disclosure has to happen. In a civil case, if the client comes in or the party says, it's going to take me 6 months to go through all of these, then you go, okay, well then 6 months, but you can't do that in juvenile. We have timeframes, we have children, we have parents. So that's part of why we're doing this, is we need to get the train moving. I know it has moved, but the engine needs to get revved up so that we're making this cross-country trip and get to the full disclosure and appropriate disclosure that we need to get. So, and I don't think the folks over here are disagreeing. Our challenge is, how do we get there? What can we agree are the deliverables right now? What do we need to do and how can we do it? One of the things that we've sort of touched on, but Ms. Wright, if you would talk about that potential universe of disclosed documents, the data points, because I don't know that we've really talked about the Guardian data points. You've seen some information, but what all is in Guardian? And it may be, that's why this is a meeting that will have to happen again, where they need to look at all the data points we're talking about. They need to look at the documents. Now, that doesn't mean we wait. That means we're getting other things happening in the meantime. Clear on that, but can you do that?
If I could just address a couple of things Mr. Foster said before I move on.
Before you moved on, sure.
So, Mr. Foster, you said that, I think you misinterpreted what I said about the department saying we've created those internally and we don't need to disclose them. I think that was a historical practice. Right now, that is no longer the practice. The department is very aware that anything that they create falls under those disclosure rules and has to be disclosed. So I think we have changed that piece of the culture. Everyone now is on notice that if you create it, it goes out to everyone. You mentioned the disclosure for the PP5s. prior to the PP5s, that's absolutely something we can work on.
For
That
folks who may not be in the know, can you say what PP5 is?
Sure, the PP5 is a preliminary protective hearing, and it has to happen within 5 days of the child's removal or from the filing of the dependency petition. So all of that investigative information would need to come from the investigative case managers, and that's absolutely something that we will follow up on and make sure that that is occurring. So that to me is when I say an easy fix, but we can identify that problem and find a solution to that issue. And I agree with you. It's really hard to argue against the temporary custody orders if you don't have the information that led to the temporary custody. So that's something we can certainly work on. With regard to client versus attorney having the responsibility for disclosure. When I first started at the Attorney General's office almost 2 years ago, one of the first things I said when this issue came up is, why is the department in charge of the disclosure? It should be the attorneys in charge of the disclosure. Caveat to that is that the department has all of the information and they still have to provide it to the attorney. So we can certainly set up a CRCU type organization within ourselves that does the sending out of the documents, but we still rely on the department to provide us with those documents. There was a conversation about us having access to Guardian so that we could go in and do that. We absolutely do not have the manpower. There are 2,000 case managers and we have just under 100 attorneys. So if you look at that time ability to go through Guardian and pull all of that out, if the case managers are having that difficulty, we wouldn't have attorneys able to be in court because they'd be pulling those documents out. The department has been more than willing to allow us to have access. But the only other state agency that I think the Attorney General's office has any access, the court also has access is to the DES's child support system. They all utilize the same programming. That's the only case I can think of where the Attorney General's office would have access to someone else's case management system. It's just not something that is done. So even if we were to take on the responsibility of sending the documents out, we still have to rely on the department to provide us with that documentation.
That is a traditional model. That's how the attorney gets the documents from a client or someone else, the attorney. So I understand that, but I understand your point, which is then the next piece is the attorney's job and the attorney's on the hook if it doesn't get sent.
Correct. And we understand that the other issue would be, we would have to have a significant increase in budget from the legislature in order to be able to hire the 30 people that we would need to be able to do nothing but disclosure all day long. So that is a barrier, that piece. Our budget has not increased in a significant period of time, so we're kind of stuck with what we have. I do want to mention a case that occurred in one of the outer lying counties earlier. Andy and Danny and I were going through that. It was where a status conference was being held in one of the appeals cases. And as we're looking at the disclosure, I've never seen a case manager so on their game. There were children's immunization records. Every single certificate mom had ever produced was in this disclosure. I couldn't think of a single thing that had not been disclosed. Case manager says, I've disclosed every single thing here. I'm willing to sign the affidavit. We're going to move this along. Her supervisor went back through and looked, to make sure everything had gone out and found 2 visitation notes that she hadn't disclosed. That was completely a mistake, right? I mean, she was on her game disclosing everything and she missed 2 visitation notes. She signed that affidavit saying that I've disclosed every single thing. Is she perjuring herself because we found those 2 extra documents? No, I wouldn't say that she is, but Parents Council is entitled to those 2 documents. So part of the problem is finding that balance of here we have a case manager who is doing her job and is making sure those documents go out. And there's still some human error where certain things get missed. I would hate for sanctions to be put in place against someone like that, against case managers who are doing their very best to get items out. Our attorneys are asked to make an avowal in court, and then we find that there were a few things that were missed. That really places our attorneys in an uncomfortable position because they're making an avowal, everything's gone out, and yet there might have been a couple of documents. We don't have a set of disclosure in these cases. In a criminal case, you've got your police report, you have your medical examiner's report, you have a finite set of documents. We know once everything is created, that's it. It's not going to change. We are receiving documents every single solitary day. So in the morning, the case manager might be able to sign that affidavit and there are provider records that come in that afternoon. And at the time that the case manager, states I've disclosed everything, something else may have come in. Or she gets a phone call in the afternoon and has created a new case note. So the disclosure obligation is constant and it's never ending. And so I think while you're frustrated, you're not receiving everything. The case managers are trying to do their best job and there are going to be mistakes. There are going to be little things that get missed. And I would hate to see sanctions imposed against the department for those types of errors. Those dramatic
Chris,
cases
I
where
have
you
to
have a
say
case.
that I don't know that there's a judge on the bench here in Maricopa County that's going to sanction because you talked to doctors. It just wouldn't happen. You have to show prejudice and everything else before you get the sanction, but I understand it. And I don't think, my experience in civil practice, documents are missed all the time. And when they show up later, usually they're not material. That's not what I'm talking about. I'm talking about the material documents. Or that, and it's not so much on the guardian side. Some middle manager just decides that we're not disclosing that no matter what. And I mean, I had that happen as a judge. But some middle manager called up and left a message on my office phone, thinking that he was calling the case manager. And the essence of it came out of his mouth about that judge doesn't know what the fucker he's doing. And no, we're not going to disclose that. And you call me back right away. And so I did. And I said, sure.
I was just gonna say, I hope you ordered them to appear in front of you.
Oh, can I add just one thing really quickly? So on the Guardian piece, first of all, at least from my perspective, attention is certainly being paid to this. Like, this is what I think about all day, every day. So to say like, we need to get somebody's attention, like, right? Attention is on it. I appreciate that. But we're also spending between 20 and $30 million a year to fix Guardian. So we're moving as fast as humanly possible, on this. And I understand it. I 100% get your point. It doesn't matter to the families, right? What they want is the stuff. But it's not like we're saying, well, we'll get to it when we get to it. I mean, we're spending a significant amount of our budget on trying to fix it.
So to just jump in, and the reality is, I can't think of any other entity that would have gotten this far. If this been a criminal case or prosecutor's office, there would have been a lot of indictments dismissed by now. If this was in the family court, the case would be dismissed or the negative inference would be drawn and fees would be assessed. Fees assessment is not an uncommon thing in any litigation. If this had been a civil case, it would have been dismissed with sanctions in all likelihood, because the answer of, well, we can't afford this, we can't do this. The reality is you folks are in this business. And your business is to make sure that when the child is taken, it's for the right reason. If a parent's rights are terminated, it's for the right reason, and to bear that burden and to help meet it. And in litigation, the disclosure obligation isn't different. It is the same. And we all learned that early on, that just because you don't want to give it or it's difficult doesn't mean you don't. So as we sit here today, I think we have the agency recognizing that. Our challenge is getting it done. And we've got current cases that really need the attention. When we were here 2 months ago, and we learned that 4 to 5 months behind in disclosure in Maricopa County, that was very concerning. And then when we were here on October 1st, we, became clear that pretty much every case has a disclosure problem, not because of the inadvertent document that was missed. That's not, I think, what we're talking about. That's just human error. And a document, a page can get forgotten, and unless there's something really bad on it, people are going to go, that happens. If it's the smoking gun that accidentally got forgotten, people are going to have a big question. Where the issue is it was the systemic non-disclosure, the case notes. And they have information. I don't know. And the judges don't know, the lawyers don't know. The same with the emails. So it's not that people are saying, oh, we want absolute perfection. I mean, it is a laudable goal, sometimes attainable, but never sustainable. But what has to happen is the systemic disclosure issues need to get fixed. Some of those are Guardian. Some of those were an historic approach that the department took that is now changing. So and I don't want just, and I did put the orders in place, and I know you're paying attention to getting these appeals moving. I have children who are stuck. I have decisions that are ready to go, that I have to wait. But it's also the Maricopa County, Yavapai County trial court judges who are now sitting here. And they have a lot more trains that have to move, and I'm not gonna speak for them. These are your voices, and if you do want to jump in, you're welcome to. But they also have to be concerned about those trains. And they want to make sure that the decisions they're reaching are based on the evidence and full disclosure. So as we sit here today, what are the procedural changes we can put in place today to get the information to them today? What are the procedural and how much? By January 1st, we'll review again what we are talking about, everybody being able to get. And then when I say that, I understand that October or January 1st is the date you have as the expectation. I think I said October, but I said January 1st is the date where the system should be functional to do this. So it will be a post January 1st process with case notes. So walk us through that schedule right now, and let's talk about what we need in the meantime and how we may be able to change it, how we keep these deliverables happening so that I don't have to stay cases, so that they can try the cases and we can get this moving.
So I did send to both Judge Young and Judge Goss a copy of, we had the IT department at DCS come up with every single data point that can be captured in Guardian. And so there were over, I want to say just about 600 different data points that can be captured. Some of these have to do with licensing, which is not a case related specific issue. It would be pertaining to, placement information. The department houses, foster parents' banking information because they pay them directly, their foster, parent. So none of that needs to be disclosed. So there are a lot of items on here that are not case related, data points. So what we did at our office is we went through those data points and we kind of color coded them. White, we just left as these are things that should not be disclosed because it would be confidential information like a foster parent's banking information or billing from, Taro sends their bill every month. And that's in a case because it's pertaining to that parent. But nobody's really entitled to that, contractual agreement between Taros and the department. So we went through and we color coded green, the documents that we felt are being consistently disclosed. And then we went through yellow documents that we thought probably should be disclosed, but we as the attorney generals are not seeing very often. So we know that there's a problem with some of these documents. So we have sent this back to the department and they're looking at that and they're coming up with a directive. Some of them, Catherine and I were just talking about over lunch. We had in here some yellow information on PSRTs, which are, my goodness, I'm losing the acronym in my brain. It has to do with when a parent is substantiated. And if they want to go back before the PSRT board to contest that substantiation, they can do that. Those don't have anything to do with regard to the open dependency case. We had those marked as yellow and Catherine said those are actually pre-dependency or post-dependency issues. So we need to update some of this. But we have sat down with DCS to say, this is what we think you have to get out. And they're in agreement with that. So these are documents that are now we're tracking to make sure that we're starting to see those. One of the reasons for the slowness of the change is, again, you don't know what you don't know. And so there were documents that I think the department were filling out and just leaving in their system. And that as the AGs, we weren't even aware that those documents were being created. Now that we have gone through that, Danny Brill sat down and went through Guardian with one of the IT people over at the department to really get into it to see, okay, what is it that we don't know? And found several items that, we thought, hey, that could be important. We need to make sure that those are getting disclosed. So we have done a big deep dive into this, but again, we're learning something new every day. Katie is learning something new every day about this system and how it functions and what information is in there that should be going out. So now that we have all of these captured data points, I'm happy to send this out to the defense bar and children's council to look at, to see, we'll send the entire list. These are things we don't think apply, but you can say, no, wait, that looks really important. And we may disagree with you on that. So we're happy to send this out to everyone to have them look at this and see if we can come up with an agreement of, these are the items that have to be sent out every single case. Now, some of them might not be created in every case. You may have a parent who doesn't have a substance abuse issue, so there isn't a, PSI records don't come in. But I think that could be a good starting point for Parents Council and Children's Council to say, hey, my client says they did this, and I'm seeing that this is a document that you create. I would like that information, and making sure that, keeping us accountable, keeping the department accountable, but also knowing what that world is, what that universe of documents actually is.
One thing I would add, and I think you folks will all, and I think talking about it, and that's, I know I shared the list of documents. I may not have shared the data points. I thought it was, but now that you just described 600, the document I forwarded to you was the list of documents, but not the data points. My apologies for that. But there may be times where you say, yeah, you're right, but then by knowing what the documents are, and I'm going to give an example. Parent never went to terrorist. Parent never did any treatment, but you ask for the bills and you find out they've been billing for treatment. That's a question to have. And you may go, that's not really relevant, but it might be in the right case. And I'm a civil lawyer. And my answer is, I want to see the contract with every provider. That may not be where you folks are at. And for good reason, but yeah, that's why I think the dialogue, and this is what's healthy right now, is folks are willing to have the dialogue. Share the documents, but now, right now, the documents you need to get through the next 3 months. And we'll come back, that's, along the way here, I suspect after you folks have met and gone through the data points and the documents that are created and with a little more information, but I think you've learned a lot more today. And there's still more to learn about what is even being created. It's like you said, and I like the line, I know I heard it before, but I didn't want to take it away from you, but you don't know what you don't know. And I think the AG found out that they don't know what they don't. And sometimes the left hand doesn't know what the right hand is doing, and the department has found out that they don't know what they don't know. There's a lot of learning happening now. Our problem is the parents don't care. And rightly, because they're saying, it's my kid. And if you can't do it right, then don't take my kid. And the kids are saying, it's my parents. If you can't do it right, don't take me from my parents. And some may feel differently. I mean, everybody's, the universe of perception is out there. So what can be done to get emails and case notes out to these folks now, not in 3 months?
So we issued the administrative directive that went out to every person in the agency that said, you must disclose all, we told them all documents. So some of the documents in here, like there's foster home licensing documents. Those aren't going to show up in the case. So we don't need the case manager deciding this is relevant or not, all documents. And then all case notes, it was specific in the administrative directive that all case notes must be disclosed. That all emails and text messages need to be copied and pasted into case notes and disclosed. So.
And the history, case notes are going to be whether the person is left or not. Case
Yes.
notes stay with
Yes.
the case.
Yeah.
Yes.
Yes, so if a case manager had been case noting emails, they will be in the system. For the Court of Appeals cases, under your order, we are running an IT search on all of those to see what emails we can find, because some of them, the case managers are no longer there. And then we are telling each individual case manager, you need to search through your emails in ongoing cases and make sure they're all case noted.
And then when can they expect to get the disclosure in this?
They should be seeing it now.
Yes.
As
And
we
it's been
said,
fairly quick. I mean, I've had, status conferences where I said, okay, well, what's missing? And they said emails and case notes. I'm like, okay, get it out. And it was a matter of days before it was disclosed. I mean, so it can move quickly.
I will say on that point, one of the reasons, and I would direct this to Judge Bustamante, because you have the lion's share of the cases. The way that we're assessing the open appeals cases, or the cases that are currently stayed, the department is looking for all of the information that they have disclosed, or that they have in their system. Some will have been disclosed, some might not have been disclosed, especially case notes and emails. Then we are also looking at what we have subpoenaed. And, then we are comparing those, because if it had been disclosed by a subpoena, then that is a disclosure. We can check that one off of the department's list, right? We subpoenaed it, we disclosed it. The problem arises when you have, items that are subpoenaed for trial, but then the case is continued on past that. So we may have subpoenaed all of the terrorist records from January through October, but the case is now in May, and we didn't subpoena records after that because we didn't need to use them at trial. So it's literally cross-checking every single document to ensure that they match and that we can say whether they have or have not been disclosed. And it is excruciatingly slow work.
That's what disclosure statements are. And it's slow and painful work for every lawyer out there in private practice and criminal practice and family practice. But is our disclosure statements then being produced so that they can look at it and go in one place, which is what you normally do. This is disclosure number 3. And in this, we've included this, this, and this.
We are building that into Guardian. So when we do the disclosure packets, it will create a cover sheet that says, here are all the documents that are in this.
Currently in Jax, there is no cover sheet, and that is a whole other issue that I have said to the department, you have got to get cover sheets on those Jax uploads, because you might have 1,000 pages in one upload and it's 25 different documents, and there is no cover sheet. So you have to go through right now, and look at, okay, we subpoenaed these records. Did they actually, going through Jax, document by document, does this match what we disclosed? Does this match what they've disclosed, to ensure that we have everything out there? It's a very, very slow process, and that's what's taking so long. Because if we're going to sign an affidavit and an avowal, we need to go page by page. And there's no other way for us to get around that. If we're asking our attorneys to put their license on the line and avow that everything has been disclosed, then we have to make sure that it's been done.
Which my sympathy only goes as far as parents and children's lives are on the line on the other side. So
Absolutely.
it is critical. George or Bill? Anything that you want? So I think we're coming back, but if we're looking at seeing at least those 2 pieces resolved, you've got the list of documents so that we can start to go through those lists and the list of data points and start to have a fuller discussion with you having more information, which you didn't have until today. Is there something else that we should do today from your perspective besides fix it? And my magic wand broke, my crystal ball, I dropped it when I was cleaning it this morning. But I'm half joking, but in reality, I can't fix everything today, but I also want to make sure we don't harm parents and children. Meantime, I know everybody in the room has that feeling, certainly the judges are.
As I indicated, Judge, I'm more than willing to look at the list that you sent. I may need to have it deciphered by somebody handing them.
I think you will, because I need it.
Yeah. The other thing I'm willing to do, and it goes back to my comment about electronic disclosure documents. Anybody. How we might make that work.
How what?
How we might make that work. Come back. I'm not sure what the timetable is, but I'd like to get within 10 days or so.
Well, that's what I was, and truthfully, it doesn't always have to be quite as big a meeting, but I think going through what each document is, happy to set a time. And if we could send those folks that document list.
Yep.
I know I sent, it was like a couple hundred documents. And also do the same with the data points. Because I think that's a smaller meeting of let's talk about what each of these is.
Well, the thing about those lists is that it gives us a better understanding of what documents get generated in this process.
Yeah.
But I would never want to say that, okay, you're limited to disclosing this stuff because there's something that may not be on that list. Okay, and that's relevant and should be disclosed. And I think that's the obligation. Because I don't know what these documents are. I mean, in what limited use they may have, there may be some other genre of documents that are not included.
Well, and what I can
Can't
see is
tell.
ultimately targeting stuff like that.
Sure.
Ultimately, you say, I just want the documents. But that can't happen tomorrow, but we can get the list, so you can say, at least looking at this list, these are the documents I want. Some lawyers are gonna say, thank you, yes, I get it, and that may be the normal response. And then ultimately we move towards, look, this has to be the documents. Like I said, in civil practice, I could never get away with just sending a list of here are the documents you want to see any of these. That's just not the way disclosure works. So, I'd like to find a time when we can, and it doesn't necessarily have to be everybody.
Can I just
But
say
to
one last
continue the
thing?
conversation. Bill, I'm sorry, I didn't even
That's
talk
okay.
to you.
No, no, no.
Go ahead.
And I just want, you know, if there's anything, clearly the response you're gonna get from every lawyer sitting on this side of the table, and you have 10 days from when you get it. That's it. That's the bottom line. And I understand where we're at, but what I would say is moving forward and in the future, that you do everything in your power to ensure that these types of documents, the disclosure that people are entitled to, that you have to get out, is done in some other way, electronically, that there's some way to ensure that these documents come in and they go out, because it's 10 days. I get it. There's a lot of documents and it's really hard and blah, 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 right? The money and everything else, like nobody cares. And if you rely on culture change, which I get it, you got to do that today, culture change, you know, paying additional people to get through these documents because we have a ton of them and we're behind, like all of that. This will never end. 30 years ago, if you were to say 2024, this is going to be the problem that you're having today, there's no way I would have thought that that was real. There's no way. That this shouldn't be fixed in 2024, that we can't have, that this continues to be a problem. So for the future, and I'm talking about clearly down the road, that this disclosure issue is dealt with just another way, and it's not done by humans.
Can I ask,
And
sorry, can I ask you a question about
Sure.
that? Because that is something that IT has brought up. Like, why don't we just, when a document comes in, immediately send it to CRCU immediately. Don't make the case manager do it, just send it out. And even there's redaction software and have it redacted and human hands don't touch it. And I want your opinion on this, if you mind I'm asking. So my thought has always been, then the case manager's not gonna look at it, right? Like, if they're not
I'm okay
forced,
with that.
you don't care?
No, that's not my
That's your
responsibility.
job.
I want the document.
Like, that's.
Do I want human beings reading it? That's their
Yes.
responsibility. And so having a system in place that relies on human beings to look at it and disclose it, to me, they have a responsibility to look at it anyway. So don't create that extra level that causes delay for me. Having some other system or some other way to go through those documents and automatically disclose those, I think is really the only way you're going to get to a point where those documents are being disclosed on a regular basis. If I was to tell you, and I know you've looked at these, the disclosure I get from CRCU, what are these people doing as far as like redacting? And it's insane to me, like that. So I'll rely on AI and whoever else you want to have go through those documents and redact it, because when I look at those,
Not
I
AI.
get thousands of pages, you know, thousands of pages of documents that are just blacked out, just insane. And then I read, and you can really tell, let's say I go through 5 pages and there's all this stuff blacked out. I know who those people are and what it is, and then they're all over down here. So there's a lot of human error. So I'm okay with like figuring out a way to, you know, to disclosing those documents, and then it gets better over time. So, and if there are issues, I should be able to say it's redacted inappropriately. There's something here. Can somebody take a look at this? And you know, but again, if there's some way to do that in the future, that would be great.
That's on the table.
That's great.
I'm just gonna say that's on the table. I've been a hater against it, but if there's a different perspective to it, then I'm open to
Just,
hearing that.
we have talked about every possible solution, allowing the defense bar to have access to Guardian directly. So you can go in and pull out what you need. I mean, we have tried,
That's not, yeah,
that's not going to
that's
happen.
not a reasonable.
No, but I mean, we have thought, okay, can you just upload everything to some sort of portal that all the defense bar can come in and get into that portal with all the, you know, documents are just sent there. We have tried to come up with a million quick solutions like that, Bill, so that, you know, I truly understand how you're feeling.
Well, and I
It's
think
very frustrating.
redaction issues, and Judge Welty may hobble me on the way out the door, are matters that judges deal with. If the redaction issue can't get resolved, ultimately, there's a way to deal with it, and the department would be the first step. That's what you do. I mean, you shouldn't go to the judge, but if it becomes a problem, there are options to try and get a redaction, but it is this clog with getting those documents to everybody so that they can see what they may not know and try and figure it out. What I'm thinking, and you said 10 days, we currently have the next DCS Guardian hearing set on the 29th. would it make more sense, and I've got two other judges who I'm the presiding on, to say, let's come back here on the 29th after you've had a chance to go through them, you've had a chance to go through them and sit down here and go through and see what still needs to get hashed out. Now, I've said over and over again, this is a court proceeding. I'm not here to decide a case. If you two don't agree, then Superior Court judges are going to hear it, and then we'll hear it on appeal on what can be disclosed or can't. But to get this moving and keep it moving, would that make more sense to people? And would that make sense to you folks? It would be October 29th in the afternoon.
I guess I've already got that date, time calendar.
You would have, that's why I'm looking at it. It's already the hearing we have set. So folks were thinking, oh, I'm gonna look in on it, I'll block that time. And so it wouldn't be a surprise that we're doing something that day. It just wouldn't be, in reality, Ms. Wright presenting on her own and giving us a status update. I'd still ask for a status update. And in fact, one of the updates I will want is, where is CRCU in its disclosure? Is it getting them out? Is it at 5 days or is it at 7? Where is that move, that needle? And I would say the same with the case manager compliance. How many documents are sitting there that have not been disclosed? And I know that's, 1,000 may come in one day, but if you see that number growing, then you know something's falling behind. And you could be online if you want for that to, and I could just handle it. I'm just, however you want to do it. And same for Judge Starr. If, the 29th. But I'm trying to keep this moving. I want to keep the heat on, as it were. I don't want Maricopa County to have my face on a dartboard saying, stop messing up my cases. So
Well,
Judge
too
Lutton,
late.
is there something?
That might be too.
Too late, all right.
I don't think it's just parents and children that don't care. For 13 months, Superior Court judges in Maricopa County and Juvenile Division have been forced to ignore the law on the timing of cases and on the application of the rules. And for 13 months, we have been told that the solution is at hand. We don't want a sanction because we don't see significant utility in moving money from one governmental entity to another. But we haven't seen a lot. I'm not questioning the integrity of anyone who has said anything to me about this problem in 13 months. I know you too well to express that. But I don't know why we would continue to trust you. We have been promised solutions that have not come. We have not sanctioned in anticipation of that. We have not ordered a special master to oversee the disclosure issue in anticipation of a solution. We have remanded cases back that we are told will take 5 weeks. You all are trying to solve this with existing resources. You are the state of Arizona. The idea that you're trying to solve it with existing resources is nonsense. The governor's office and the legislature have an obligation that if they remove children, that they can move them through the system in accordance with the law. And I appreciate that the purpose of this is to facilitate moving forward as best we can. But as best we can has not worked. And we are beating back trial court judges who want to go with extreme measures because we are working administratively with state entities to try and solve common problems. We are about out of time. So collaborate forward, but there will be consequences. And I don't know why there isn't a special master overseeing all of this now, given how little meaningful movement we have seen. The Department of Child Safety spent millions of dollars on a computer system that doesn't work and has wholly failed parents, children, and the ability of judges to follow the law. And you all want to solve the problem with existing resources, with the exception of a law firm that came in to do some review work. And I just have to say, that is wholly inadequate to the scale of this problem. Because we're talking about phase 3 in February or March of next year. I mean, we're gonna continue cases because nobody with a bar card can tell us, and I gotta be quite honest, a year from now, if I had a bar card, I wouldn't avow that disclosure was complete, given this. Because I have to count on a case manager moving something into the right box, and I haven't seen it. And if I had a bar card, I wouldn't have vowed that in a year, based upon what you're talking about. So I don't see it getting better. And I'm not sure the answer is just patience and trust. So, I don't have any of these cases. That's probably fortunate for you all.
You have had that in the past, though.
Oh, I have. I spent 3 years on it, and they know. They're not surprised by this tone of voice, I suspect, either.
I've heard that tone of voice before directed at me.
But I mean, this is not a thing that we can be patient. It just isn't. It just isn't. We're talking about this like, we gotta fix a business division. I mean, cases are being continued every day. And we've got children that should have been adopted already that aren't because of this avowal. And we ought to be ashamed of ourselves. So yeah, move forward as best you can move forward, but I suspect we are not gonna find that adequate.
And I think that's, there are different places, and you're in a place where you have to figure out how you're gonna handle that piece. And I'm not gonna disagree with anything you said. I'm trying to maintain, and you understand, we're trying to get this, and that's why I'm coming back every 10 days. I
I'm
don't
not
take
here
it
to
to
trash
trash.
anything, but I'm also not here to sit here and listen to all this and walk out of the room as though I'm okay.
You're not. You shouldn't be, because we are still broken. I'm not okay. I have 100, you have thousands, so you're, and far more judges than the 19 I have who are being hobbled by this, and I have the same thing. And on the other side of all of that is, it doesn't matter for any of us in the sense that it's about children and families who are being impacted, children who aren't being adopted or aren't getting back with their parents the way they should. So I appreciate everything you said and respect it. I'm gonna do my best to keep my foot on the gas so that we get there and it's not another, year and we're still sitting here in the same place. I do feel good that we've gotten at least the CRCU backlog cleaned up, which was 4.5 months on you folks. So hopefully that gets you in a better place. That the emails are starting to get there where they end case notes. So I'm glad you're here so you could hear what's going on. And I 100% respect the complete dissatisfaction. I don't think anybody should sit here and say, I'm really proud of how we've done everything. But what there is we do have to get it moving forward. So I want to be back here on a regular basis and making sure that as soon as possible, you folks are moving your cases so that my appeals can move, so that we can see these families where they need to be. So thank you, and I hope you know the respect I hold you in and why I do know you know how important this is. So I hope you don't mind me quoting you, but as you said, juvenile court is the one place that the courts do God's work. And I hope you don't mind me attributing that to you, but it's true. And that is the one place that all the lawyers in this room are doing God's work and all the judges are in that sense. And I'm not invoking God, and please don't take it. I'll probably get an email from somebody who complains about that. I'll own that. But it is too important for all of us. What I do feel better about is an agency, a director, unit director, division director, that see it differently than it was seen before. So at least it is moving forward. Now we got to get it to full speed so that this isn't an ongoing problem. And Judge Bustamante, is there anything you wanted to add? No.
Thank you.
The judge, does the 29th work for folks that afternoon?
Yes,
Okay,
of course, me.
so does that work for you, Ms. Slaughter Owens, in case you have to be down here helping me run these?
Yes.
She may be on, oh, I'm sorry, you're,
Rachel.
Rachel.
Yes.
I'm sorry,
That's okay.
we've only
We'll
just
make it work.
met,
That's
and I
fine.
apologize.
That's okay.
I will now definitely not forget who's who.
That's okay.
I promise. So if the two of you, because I think you want to be a part of this, that way you can keep the juvenile court committee appraised of what happens. And we'll just keep this moving in 10-day increments. So in 10 days, what I expect to hear is we are actually getting the disclosure and that we're checking and making sure we will have an update on where status stands with CRCU, with the disclosure, the documents broken down so we see, are they actually getting moved? Perhaps we can talk about that automatic piece at that point. That probably makes sense. Do you folks think it makes sense to have the automatic? If it comes in to a file, it goes to CRCU and gets to you folks in an automatic fashion. Redacted, you folks can deal with the redaction, but have them here to talk about that in 10 days?
Sure, I'm here.
Okay.
Any way that we can get documents immediately is.
And I would have to caveat that there are 7 other counties in Division 1
I know.
that do not go through CRCU.
I
Right.
was gonna ask that, if there's a way to kind of drill down and see what the status of disclosure is in the non-CRCU.
And from our,
Good thought.
from
Thank you. That's
our
why you're here.
assessment, those other counties are doing a better job of getting disclosure out in a timely manner and more thoroughly than we are in Maricopa County.
So in that report update, can you provide us every county, which is what we've got before, and that way we'll share that with you and you can say, okay, and that's what we did see. The Maricopa County is the one that has the backlog and is really struggling. It seems like the other counties, because it is done, aren't having the same problem.
And
Although I do have stays. And I know one of your cases is stayed.
I think I might be.
Yeah, okay, so it's not, and that is in part, I will tell you, the reason that is what wasn't being disposed of emails and
He's
things.
complaining or bragging?
And that's why I say every one of my appeals has stayed is because of the email and case note problem that just permeates everything that has been happening. So I know that there was frustration that I was sending them all back, but in the end, I'm like, every one of them has a problem that somebody down there is gonna have to look at, unfortunately.
Don't look at me. I'm not gonna agree with you. I hear what you're saying.
I know, I do. So we'll be back here. I'm going to, what time were we scheduled to start that other one, 2 o'clock or what?
1:30.
What time?
It was 1:30.
1:30, so 1:30 on October 29th. If we don't have this room, we will have another room here. We'll set it up, it'll be broadcast. We'll have folks who can be and want to be here in person. If your spokesperson can't be in person, they can participate remotely, but Judge Foster, I think he was planning on being here. Anyway, I would ask that we try and do a little more discussion with the other counties. For Judge Starring, we have included all the Division 2 the public lawyers representing families and children. And Judge Starring, you've been quiet. I haven't seen you raise your hand or want to say something, but I'm going to give you the last word.
Well, Judge Goss, I have a lot of thoughts in my head about this problem, but they haven't crystallized to the point that I want to throw them out. I'm grateful for the opportunity for Division Two to be included in this discussion. As you know, we're approaching it on a case-by-case basis, but that's probably due to the lower volume and that enables us to do that. Now, I think for now that's probably all I want to say, and I'm looking forward to the next meeting. I was actually on time, but we couldn't log in for some reason, which might be my own ineptitude and certainly not the responsibility of anybody else. But
And
that's
I
all
will
I've got.
apologize, because I am the one who at one point sent out the wrong link. It was the link to your meeting, and figured that out yesterday. And so to anybody who didn't get the updated link, I will be much more careful and say, is this the right one before I send it? And make sure that we get the word out to folks. So, all right. Then October 29th, we'll hear more progress. Judge Welty, our goal is to get it on, keep the track moving so that you can say, good, finally. And for Judge Bustamante, Judge Young, you can actually see the cases moving and I get the appeals back up here and get it taken care of. But thanks, everybody.
Thank you.